I am for the private respondent, my lord.
I am appealing for the National Commission for Scheduled Castes.
I am for the petitioner as well as the appellant. My case is that I am not seriously aggrieved in the circumstances and my life is in the danger. In fact, the respondent, particularly the police authority, they are simply violating Article 46, Article 23, and even the speed of Article 226, they are not maintaining. Now, if your lordship kindly see, I being belongs to a scheduled caste category, and there is a dispute between me and the private respondent. And I went to the police station to lodging the complaint on 14th October 2023 at about 9:30 like this one. And up to 2 a.m. I was sitting in the police station. I do not find any officer. Ultimately, when the officer came into the police station, he then asked me, what do you want? Well, this is my complaint because the private respondent and his associates are torturing me and using very nuisance and all unparliamentary words upon me. You can take the steps and this is my representation. Upon going to the representation, police authority says, we are not accepting this representation. Either you write a fresh complaint, otherwise I will take a stern action against you. Ultimately, they taken my representation from my hands. The main copy, 2 copies. One is the office copy and another is the original complaint which I intend to file before the police authority. 2 copies has been taken and ultimately they are threatening inside the police station, taking stern action, arresting me. And ultimately he then compelled me, yes, I am giving you the dictation, you follow, you then submit. Finding no other alternative, I make that representation. That has been annexed. But the original one, the 2 copies, that has been taken by
the complaint said to be given by you, not as per the dictation.
As per their dictation.
Some FIR has been registered, now charge sheet has been laid. There is a counter complaint given by the private respondent. In that also, charge sheet has been laid. That matter is before the trial court. Now, therefore, the learned single bench has said, you please raise all the issue before the trial.
Now, how myself I will be aggrieved? How myself I will be aggrieved? Your lordship kindly see.
If according to you, after this charge sheet has been filed, still the private respondent is harassing you, then you file a complaint.
Lordship kindly see, I am coming to the order passed by the court below.
We have read the order.
Yes.
Madam, may I submit? This is a civil nature, my lord. Civil suit is pending in between the parties, my lord. This is the order. A status quo order, my lord.
If your lordship
and in the meantime, it has been filed in the year 2022, my lord. Kindly go through that.
Page of the order. If your lordship kindly see the order sheet.
Yes.
It was duly signed by him as well as. This is the version that was given by the petitioner to the police for registering FIR, the petitioner. This is the version means the second copy. The first copy has been taken. That has not been recorded. And there is no whispering about this. And if aggrieved, could not have waited till 6 November 2023 for the first time to it. This is the 6th November complaint. If your lordship kindly see, the 6th November complaint is the subsequent representation I made to the different authority, including police, including the chairman, National Commission, this. The court finding is that there is no whispering about this one. If your lordship kindly say, on the day, the sanction was granted by the superior authority to file the charge sheet. Lordship kindly see, the Calcutta police is now so.
Sir, how in a writ petition we can direct that offence under the SC/ST Act should be included?
Yes, that is the point.
No, that we can't.
Lordship kindly see, if your lordship kindly see, I intend to file the supplementary affidavit before your lordship. That will unfold the entire picture.
Madam, kindly allow me to submit my part.
Yes, submit. Supplementary affidavit.
Suppose he wants to add, can get into the box and.
Lordship, kindly see. Kindly see the order sheet. It was duly signed by him as well as the petitioner to the police for registering FIR, the petitioner. This is the version that was given by the petitioner to the police for registering FIR, the petitioner. This is the version that was given by the petitioner to the police for registering FIR, the petitioner. Not leave may be granted to file the supplementary. And give it একটা মিনিট বলে দিই তোমাদের নিয়ে।
কপি টা দিন,
এর কপি দিয়ে দাও তো supplementary।
অ্যাডভান্স কপি দেওয়ার ছিল,
এই তোমাদেরকে পাঠানো হয়েছে,
না কেউ পাইনি।
তোমাদের পেয়েছো?
না।
হ্যাঁ?
না।
Yes, not been so.
Now, when was this complaint given? On 4th of September.
Now, if your lordship kindly come to that, the entire incident which has been taken place inside the police station, that has no record. Only the concerned CCTV footage, if that can be located. Yes, otherwise,
This complaint, page 4 of your supplementary affidavit, was
Page-
given on 4th of September. What happened to that complaint? We will direct them to investigate that
if your
complaint.
lordship, if your lordship kindly help me to tell this one in supplementary affidavit,
Supplementary affidavit, page 4.
page, uh, page 4.
This complaint was received by the Posta police station on 4th September.
No, my lord, this is that point, this application, this is the last incident has been taken place for the sake of for unfolding the truth. How I myself, my lord, that page 4 is not to be taken, my lord, what I am.
Then why have you filed this page 4?
My lord, the last incident, few days back, another incident, that document has annexed herewith. If your lordship kindly see,
Sir, we will give you liberty as given by the learned single bench to go before the trial court and say that further investigation has to be done. SC/ST Act offence has to be registered, etc. You will. Title suit is also pending.
now.
Yes, madam.
Now,
Yes, madam.
what is my?
They are trying to use that SC and ST
And SC.
certificate, my lord, to evict me, not through the process of law.
Your lordship-
As there are kindly allow me, as there are several cases in between the parties on the
Separate course of action.
15th October, there was case and counter case registered, as their case was numbered as 96 and my case was numbered as 97. After the passing so many days, they wanted to narrate another story with in accordance with SC/ST.
If your lordship.
That is on 6
Very well,
11,
very-
my lord.
very well. Whatever my learned friend says, if your lordship kindly see the contents of my date application, if your lordship kindly see the can application 2, if your lordship see the writ application.
Page. Can 2 page number.
Yes, yes, your lord, I'm telling you. Para 5, page 4, page 4. The story they are making before the court. If your lordship, this is the writ application which has been filed before the single bench. That the petitioner states that under compelling circumstances, the petitioner and his other family members, including his brother, went to the police station and contact the duty officer according to the advice of the duty officer. The petitioner went to the medical college examination. Thereafter, at 2 m, petitioner was able to meet the duty officer. Accordingly, the petitioner handed over a complaint contains a detail of atrocity taken place on the petitioner and his family. Be it mentioned, the petitioner has specified the hate speech using the respondent number 6 on the scheduled caste community. At the beginning, the said police officer asked your petitioner to hand over the complaint along with the second copy. Accordingly, the petitioner handed over all the copies. Upon the receiving the same, the concerned police officer started threatening. My same friend says on 6th November.
And this has been filed in December.
Please.
Lordship, kindly see the honorable single bench has observed coming at the delayed stage. Finding the 6th November, I make a lodge complaint. But in the
You are not answering our question. When charge sheet has been laid, how a writ court can issue a direction to include an offence under SC/ST Act?
that is the prime officer.
So therefore, liberty has been granted. to go to the trial court to file for an application for further
But-
investigation.
One judgment I am placing before your
Ah,
lordship.
yes, you place. You are before the wrong forum.
The case of Anand Tarun Karmuzi versus State of Maharashtra. Well, Lordship, kindly to the para 11. This court has a wide power. In invoking Article 226, and Supreme Court can invoke in Article 32. This writ court is having wide power at any stage, further investigation, re-investigation, de novo proceeding drawn up. All the powers are in the hand of this honorable court invoking Article 226. My lord, I am appearing in the writ jurisdiction. Now, this reference, why I am making this honorable court? Because 226 is having,
Sir, this was a case where they wanted the investigation to be transferred to CBI.
my lord, ultimately, my lord, our section, our application in the reference, second application, we also make a prayer before
No,
that.
Your
If the court,
writ petition is to give effect to your representation dated 6/11/2023 to arrange for necessary protection for the petitioner and the family members and to set aside the FIR dated 15/10/2023 and draw up a fresh FIR. The court considered the prayers and found that the FIR is now, investigation is over, charge sheet has been filed. Counter complaint, charge sheet has been filed. Therefore, they gave liberty to go before the concerned trial court to seek for further reliefs. What more can be done? So far as any threat is concerned, there we will give you liberty. Suppose it's after this order, if he is threatening you, that the police will separately investigate that. If there is a threat perception, they will give you protection subject to payment of cost for that protection. This intra-court appeal by the writ petitioner.
my lord, one prayer before, there is a
Please.
4 days delay. My lord, 4 days delay we can also be condoned. 4 days delay.
This intra-court appeal filed with the writ petitioner is directed against order dated 2/5/2024 in WPA 26175 of 2023. There is a delay of 4 days in filing the appeal, and since the explanation offered is acceptable, the delay is condoned. The writ petition was filed to give effect to the petitioner's representation dated 6/11/2023, semicolon, to provide protection for the petitioner and his family members and to set aside the FIR number 97 of 2023 dated 15/10/2023 and draw up a fresh FIR upon fresh inquiry. The learned writ court, upon considering the facts, found that the FIR has now matured into a charge sheet and charge sheet has been filed before the learned trial court. That apart, there is a counter complaint given by the private respondent in which investigation was complete and charge sheet has been filed and both matters are now pending before the trial court. Therefore, the learned single bench rightly observed that the writ petitioner shall be at liberty to agitate all points at the time of trial, comma, if the same ensues, ENSUES. It is submitted by the learned advocate appearing for the private respondent that civil suit is pending between the parties in title suit number 2608 of 2022 before the learned 8th bench City Civil Court at Calcutta, and there is also an order of status quo. The learned advocate appearing for the petitioner placed reliance on the decision of the Honorable Supreme Court in Anand Tanur Karamsi, so and so, civil appeal number so on 13 of 2023, dated February 24, 2023. We find the said decision will have no application to the facts of the case, as the matter before the Honorable Supreme Court was whether the prayer for transfer of investigation to the Central Bureau of Investigation was justified or not. Therefore, we are of the view that the learned single bench was right in disposing of the writ petition with certain observations. No, dismiss the writ petition with certain observations. If according to the petitioner, he and his family members are continued to be threatened by the private respondents, even after the charge sheet has been filed before the learned trial court, it will be well open to the petitioner to file an appropriate complaint before the jurisdictional police, who shall consider the complaint and cause an investigation and assess the threat perception. And
Let's one prayer before your lordship, subject to the leave of the court, my lord.
Yes, sir.
Supreme only will, if your lordship kindly include the Supreme Court guidelines given in the Dharampal versus Bharati, where even says a de novo investigation, even after the charge sheet is filed.
Yes.
That can, if your lordship say.
Yes, sir.
My lord,
Thank you. Next,
one thing, my lord, as I have not received the supplementary affidavit, I have not,
you ask your friend.
I am denying, my lord, the contentions. And second thing, my lord, kindly note it down that the brother of the petitioner, namely Ritesh Sonkar, has also filed a writ petition with the same cause of action, being writ number 5313, WPA number 5313 of 2024.
The learned advocate appearing to the private respondent submitted that the copy of the supplementary affidavit
But we do not have any knowledge.
and private respondent does not admit any of the allegations made there. Further, it is submitted that the brother of the appellant has filed another writ petition on the self-same cause of action in WPA
5313, madam.
of 2020.
5313 of 2024. Grateful, madam.
Next,
Serial number 6.